Well, hello there, and welcome back to the Employment Law Show. We're back for another week. Good to have you along with us. John Scholes, Lior Samfiru as well, employment lawyer at employmentlawyer.ca. Off the top, always give you the contact information because at the end of the day, that's what you need to know and keep with you. Phone number, 1-855-821-5900. Help at employmentlawyer.ca to reach out through email. Lots on the show over the course of the next half hour. The main topic is quiet firing. What you need to know about that is actually not quiet, so we're going to get to those talking points a little later on in the second segment. Phone calls, emails, rapid fire at the end. It's a busy show as usual, but we like to get started with the week that was. Case of the day. Lior, what do you got going on this week, pal? What's happening?
Johnny, great to be here to talk employment law, to solve some workplace problems, and to tell our good viewers what they need to know about this very, very important topic. We have a lot to cover on the show, as we do every week. And why? Because we want everyone to know their legal rights. Sometimes people stop me on the street and say, hey, I learned something from you. I'm so glad that I know that there's resources. I'm so glad that I understand my rights. That is the point of the show, so that you know what to do if you're facing a workplace problem, so that you know you're also not alone in that situations. There's helps, there's things that you can do, and of course, we're there, my whole team is there across the province to help you ensure that you are not taken advantage of, that you can pursue and follow your rights, whether you've been let go, you've been constructively dismissed, if you've been discriminated against, if your bosses change the compensation, change the terms of employment, or maybe you've been harassed by your employer or by a colleague. In all those situations, on the show, you'll learn what to do and what it means. But beyond this show, you can reach out so we can roll up our sleeves and get to work in helping you actually enforce those rights. So don't be bashful. Always reach out. There's no bad questions. There's only solutions and answers. Now that we know that, let's get started. Let me tell you about a matter that came across my desk very recently. I spoke with a gentleman that found himself in a very difficult situation, certainly very frustrating. So he had worked for over 14 years with an employer, reached a very high level in a senior role with that employer. And a few months back, a headhunter reached out to him wanting to have him join another company, pursued him pretty hard, phone calls, and eventually agreed to take him out for lunch. And eventually, after all these meetings, this person agreed to join another company. They made him all these grandiose promises, financial stability, and even more opportunities for growth. So he said, okay, man, it sounds awesome. I wasn't looking to leave my employer, but with all these promises, I'm going to do it. So he joined the new company, and fast forward about 6 months later, actually just under 6 months, company decides, you know what, we don't feel it. It's not working out for us. They let him go. Of course, he calls me. He's very upset. Why? Well, he left a secure job for 14 years where he was valued, respected because of these promises. And now 5.5 months later, he is out of a job. So what does this mean for this person? Well, this is a situation sometimes we refer to as inducement. And that means that he was recruited away. He was induced to leave a secure job only for that new job to then let him go. From a legal standpoint, what happens with inducement is now when it comes to his severance, he needs to get credit for the time he spent with the previous company, that 14 plus years that he had with the company. So when the new company let him go after 5 months, what they were actually doing is they were letting go a 14-year guy, and they have to pay him severance as a 14-year guy. For him, that meant about 16 months of severance. Keep in mind, he only worked for the company for 5 months. But that's what happens when you get recruited from another job, only to then be let go fairly shortly thereafter. You're going to get enhanced severance that recognizes that time with the previous company. So what that does, it gives him more time now to find another job, to make sure that he's not obligated to take the first position that comes along. It's that cushion that he needs. So that's a very important reminder. There are many factors that could significantly increase the amount of severance that you're owed. This is one of them, inducement. Certainly, if you've been induced or recruited away from another job and then you're let go, man, you have to call me immediately. You may be owed a lot more than you realize.
If I'm an employer watching this now, Lior, how do I go, man, I got to protect myself against something? Is there a mechanism for an employer to protect himself against that?
There is, and I'll reveal it since you asked. The only way an employer can protect itself in this situation is with a proper employment agreement that specifically limits future severance and also says we're not going to compensate you for any past service. So an employer that hires a new employee, certainly if they recruit that employee from another job, should have that term in an employment agreement. If they don't, and this employer didn't have that, they're not protected and they're going to have to pay a lot of severance. So depending on your prospective employee or employer, that's what you have to do.
So I'm assuming if you're the employee that's being induced to go to this workplace, that is one thing. If you're smart, you're going to look through that agreement and say, I noticed this little clause in here. I don't like that. So can we get that removed? And would you have a chance of actually getting it removed if you negotiate with them?
So in all situations, when you start a new job and you're presented with an employment agreement, you should have it reviewed properly so that you understand what that agreement says. It's not just about your salary or how many weeks vacation. There are many other important terms, like is there something there that limits your future severance? And yes, you can negotiate those terms. You can go back and forth with your employer and make that agreement better. That becomes that much more important. If you're going to leave a secure job to join a new company, you don't want to agree to terms that are problematic, that are going to cost you money. They came after you, so why would you agree to that? So yes, you can negotiate, you can change those things, but the best advice I'm going to give you is anytime you start a new job, doesn't matter if it's a senior role, entry-level role, whatever the circumstances, let me see that employment agreement before you sign it. Let me tell you what it means, what it does, and how to negotiate it.
And I assume since they came to him, he would have more negotiating power. You want me, here's what it's going to cost to get me. You keep, all the lunches and everything, right? I don't like that. You got to remove that.
Absolutely. He has all the bargaining power, all the leverage. He could have easily done that. In this case, thankfully, he didn't need to because the company didn't try to sneak in those terms, but he absolutely could have if he wanted to.
Is there a threshold? He was a 14-year guy. He was there for 6 months, so it was a small window. Is there a threshold to how long he would be with a new employer where no longer matters, or it's no longer the responsibility of the new employer to pay the back pay of 14 years?
Yeah, so if you start a job with a new company and they let you go 20 years later, obviously they're not going to have to worry about what you were doing 20 years ago. So generally speaking, that enhanced severance based on past service is going to happen in the first 3, maybe 4 years of employment. Once you go beyond that, it's going to be tough to say, well, you should also compensate me for the previous time. But again, some cases that could be extended. As always, the devil's in the details, which is why you call me if you lose your job.
And call anyway for more information, and sometimes your calls will be aired. We like to talk about them and learn from them, the good ones anyway, all of them actually. It depends on what we're talking about for the show. Reach out to Lior anytime, like I said, 1-855-821-5900. First phone call of the show is coming up right now, pal. Let's listen for it.
My wife received a package from her company. She's been there 20 years. She's going on 60 years old. She was an executive admin to a VP. They offered, I think, 15 months, and I was wondering if you felt that was adequate or not due to her age and her position.
Give me a sense. What was your wife earning? How much was she earning approximately?
Approximately $75,000.
I'm going to say no.
So here's the thing, before I tell you what she's owed and kind of answer that issue, but I think most people, if you would ask them kind of on the street, say, hey, this lady was offered 15 months severance, what do you think of it? They would probably say, that sounds pretty good. That's 15 months pay, right? Well, it's not good, and that's why we have the severance calculator that I'm going to talk about. That's why you call me if you lose your job, because chances are your severance is not going to be good. Sometimes it's extremely horribly awful. Other times it's just not appropriate, but it's probably not enough. So for this person, yes, she's owed more severance. I'm going to show you how much more severance she's owed, but I'm going to tell you, of course, I've alluded to it, how you can find about your severance and your entitlements. All you have to do is use the severance calculator at pocketemploymentlawyer.ca. I'm going to use that right now, and let's see what this person is actually owed. So we know that this person is in their late 50s, 59 years of age, been there for over 20 years, was offered 15 months. The right amount is easily 18 months. It could be more than that, but certainly no less than 18 months pay. Now, here's why that's important. Those extra 3 months are valuable. Why? Because it's going to be more challenging to find another job at 60 than it would have been at 40. So the more severance you have, the more time you have to find another employment. That's the whole point of severance. So very important. Use that severance calculator at pocketemploymentlawyer.ca or just call me to find out how much you're owed.
You know, it's interesting, too, because this particular phone call, she seems to ring the three big bells of having the robust payment. 20-year service, long time, almost 60 years old. She's getting up there, plus assistant to VP. So it's a fairly robust position as well. So the number is going to be higher, right?
The number is going to be higher, and it's almost in every situation, John. So common. When someone's let go, they're not offered anything remotely close to adequate. Now, in this case, it wasn't even that bad a severance offer, but it was still 3 months short of where it needs to be. 3 months' pay is a lot. So no matter what you are, who you are, and how long you've worked, we need to talk, of course, if you've lost your job.
That was phone call number one. Let's get to phone call number two. Listen up.
My husband has a mental illness issue. Wasn't performing to the standards that he should be performing at work, and also got letters that said he wasn't performing well. And he did get a package. For us, that package looked really good, considering because he disclosed he had a mental illness and it's backed up by some physicians. What was your kind of take on that?
So the concern in a situation like this, John, is that he was let go because of that condition. And to the extent that his performance was lacking, it may have been affected by that condition. And that is a problem. You cannot be let go, punished, disciplined if your health is not well. If you're suffering from a serious medical condition, even if it impacts your performance. And that would be a human rights violation. If this employer says, you know what, you're not doing a good job, we don't care about your health, we don't care about the reasons, even though we know the reasons, we're going to let you go. Again, that's a human rights violation. An employer cannot do that. Now, what should this employer have done? Well, if number one is accommodate this person. Maybe there's a different role that they could give him. Maybe there's additional help and support that they can provide to allow him to do his job properly. And if that's not possible, allow him to be off work until he gets better. What they cannot do is say, well, too bad for you, we don't care, we're going to let you go. Illegal. Same with you at home. If you have a medical condition that affects your ability to do your job, I want you to speak to your doctor. I want you to get something in writing. That doesn't need to say what the condition is, just that there is a condition that affects your job. Your employer cannot punish you, and by doing that, you're actually protecting yourself and your job. And if your employer tries to do anything to you in that situation, call me right away.
All right, good start. We'll take a short break here. We'll get to our third phone call on the other side, and our main topic, quiet firing, what to do when it happens to you. That is all just ahead with more of the Employment Law Show. Stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, we are back. Thank you for hanging in there through the break. Employment Law Show. Always reach out to Lior, as you know, 1-855-821-5900. Help at employmentlawyer.ca. And the website, the only one you should go. Don't be Googling nothing. Just go to pocketemploymentlawyer.ca. We'll get to our main topic here momentarily, but phone call number 3 is coming up right now. Let's listen up.
My husband was informed that there would be a senior job position opening at his company in another department that he'd be suited for. Weeks after he did the interview, they said he didn't get the job because he would be too stressed out. He did have to take a stress leave for a short amount of time a few years back. Is this not discrimination?
What do you think, Mel?
Yeah, it could easily be discrimination. If he was dealing with a medical condition, he took care of it, he was off work, and now they're holding that against him. They're saying, well, we don't want this medical condition to impact us, so we're going to not give you a position, we're not going to give you a promotion. That's not legal. That could easily be a human rights violation. Obviously, I would want to know more about how serious was the condition, how long he was off work, and how long ago that was. That said, as a general rule, your medical history, your medical background, and your conditions that you're dealing with should not interfere with your history, with the company, or with your promotion in the company, and the status that you have within the company, and certainly not with your job security. So this could potentially be a human rights violation. They don't get to decide that. They don't get to make that determination. Now, what they could have done is said, well, we need something from your doctor to say that you're able to do this role if they had concerns. Once he provides that, that's it. They don't get to make medical decisions on behalf of the employee. Same with you at home. If your employer is deciding for you what you can and cannot do because of your health, that's not proper. That could easily be a human rights violation. And call me so that I can set them straight.
Main topic time, quiet firing, what to do if it happens to you. I guess the first question, Lior, off the top is, what does it mean, quiet firing, and why do employers do it?
So quiet firing is a term that's become a bit more commonly used in recent years. You know, when I started practicing law, that term didn't exist as much. And the idea behind quiet firing is an employer creating a work environment that discourages work and that encourages someone to leave by creating an environment that's unfriendly, that's hostile, or changing the terms of employment, changing hours, creating that environment, that atmosphere where someone's going to want to leave. Now, why would an employer do that? Well, because an employer may hope that someone is going to leave and resign instead of having to be let go, so that way they don't have to pay severance. The idea is, well, if the employee leaves, we don't let them go. Think how much money we pay for that or how much we save for that by way of severance that otherwise we would have to pay. So that's what quiet firing is. Another term that we often use for that is constructive dismissal. An employer changes the terms of employment, wanting to make an employee leave. But as we'll talk about in a second, the law comes in here and says, not so fast, employers. So stay tuned to that.
So there's got to be some obvious signs, or at least maybe not so obvious signs, that they're trying to push you out of the job, right?
Yeah. So if your job is no longer what it used to be, the expectations have changed, you're not treated properly, maybe you've been demoted, given less responsibilities, being told or shown that you're not as valuable as you were before. All these are signs of quiet firing. All these are signs that your employer is trying to gently but firmly, I guess, push you out or try to convince you that this is not the right place for you. So it's obvious. Someone that goes through this situation knows it because they've worked for the company for a while. They know how things used to be, and now they're different. So if you're getting the feeling that your employer doesn't want you there, there's probably a reason, and it's probably not your imagination. It's probably something that your employer is actually actively doing.
Does one quit if they feel this going down, or how do they handle it as an employee, right?
So in an ideal world, John, you don't quit unless, of course, your employer does something that doesn't make continuing to work logical. You know, if they simply don't talk to you nicely anymore, you may want to say, well, no, I'm going to stay here. If they want me to go, I'm going to let them have me terminated so I can get the severance. But if your employer changes your employment term, they reduce your hours or your pay, or they demote you, or they take away responsibilities that you have, you may be able to quit then, to leave, and still get severance. That's what a constructive dismissal is. When you're let go, when you consider yourself as being let go, even though the company has not let you go, you're saying, no, employer, by treating me this way, by changing the terms of employment, or by creating this hostile and negative work environment, it's as if you've terminated me. Now you have to pay me severance. So even though the employer is doing this to try to avoid having to pay you severance, the law comes in and says, no, no, no. You still have to pay severance because this employee is not leaving voluntarily. They're leaving because you gave them no choice. You put them in a situation where they couldn't really stay. So now you're going to be owed your full severance. Of course, the problem, John, is if you don't do that, if you don't leave, your employer change your job, your pay, and you stay, you're potentially giving them the right to do it again. So in some cases, it is much better to quit than to stay when your employer is quietly firing you. Of course, I don't want anyone quitting without speaking to me first.
Well, that's the thing. As an employment lawyer, how do you help in that situation?
So number one is I can assess whether or not this is a quiet firing or a constructive dismissal. I can assess whether or not you can trigger this termination and get severance. I can also figure out how to do it in a way that maximizes your amount of severance. And beyond that, of course, if you don't want to leave, if you want to stay, I can probably get your employer to back off and get them to go back to the way things were, because once they hear from me, they're going to be on their best behavior. So you don't have to deal with quiet firing on your own. Let me help you. We do this every single day.
Quick break. We'll get to another website we use called terminationquestions.com, free and anonymous for you to use as well. We'll do that on the other side as we continue more with the Employment Law Show. Stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back to the Employment Law Show. Thanks for sticking around for that short break. We're back with you a few minutes ago here. Contact information once again to reach Lior and his team. Phone number 1-855-821-5900. Email to go along with is help@employmentlawyer.ca. And the only website you need, which has, by the way, rolled into it, the severance calculator, that would be pocketemploymentlawyer.ca. Obviously free and anonymous to use, but yet there's also terminationquestions.com. There's all kinds of options for you out there in the world of employment law to get some questions answered. And from it, our first question for the show today, Lior, again, terminationquestions.com, free and anonymous. I was let go after 18 years with the company. I'm a 47-year-old in a specialized technician role. When I asked about a larger severance package, my boss said the termination clause in the contract I signed did not allow for that. So what do I do?
This is such an important question, because what we often see is employers trying to limit their future severance obligations by having an employee sign an employment agreement that says, hey, if we let you go, we're not going to pay you your full amount. We're only going to pay you a small portion. And it's easy to think, well, if I sign that, now I'm let go. Well, I'm not going to get my full severance because of what I signed. Well, here's the thing. In many cases, most cases, probably 85% of these cases, those terms in the contract that you signed are actually not enforceable. They don't actually limit your entitlements, and you're still owed your full severance. So I don't want anyone to assume, well, I signed something, they told me I did, I know I signed something, so that must mean I'm not getting my severance, I'm only going to get pennies on the dollars. Not even close. You're still very, very likely owed your full severance. Regardless of what you signed, I want you to call me. So let's go now once more on this question to the severance calculator. You'll find that, as John said, at pocketemploymentlawyer.ca. And let's see what the right severance amount is. So we know that this person has been there for 18 years. At the age of 47, we don't know the severance that they've been offered, but what we do know that he's owed 16 to 20 months pay. 16 to 20 months. That's why you use the severance calculator, whether you lost your job, whether you're worried about losing your job, maybe you're just curious. pocketemploymentlawyer.ca.
Want to mention as well that during the week outside the show and all the radio shows, Lior and members of his team do a live stream that's on Facebook, YouTube, LinkedIn, at stlawyers.ca to join into that conversation. And in 12 years of doing this show, Lior, I've never seen this before. Here's the question. See if you can tackle this one. My employer has recently announced that they will be implementing a fine system for incomplete tasks and infractions. For example, if you're caught not following the dress code, pay will be reduced for that period. Is this legal?
No, John, it's not legal. Sorry, I don't mean to make light of this, but It just makes me shake my head sometimes at what employers think that they can do and get away with. So let's be very clear. A fine, a penalty, it's not legally enforceable. By the way, forget about employment law. Generally, in any contract, if you sign a contract that says if you do something, there's going to be a fine or a penalty, it's not enforceable. Certainly not when it comes to workplace rights. So no, your employer can't say, if you're late, you owe us this money. Or if you don't wear your uniform, we're going to penalize you $5. None of that is legal. Now, in some situations, if you cost your employer money, if you lose a client that is worth $50, you owe us $50, they may be able to do that as long as you sign an employment agreement that specifically says that. But it can't be a fine, it can't be a penalty, it has to be tied to actual amounts that the employer lost because of you. That's extremely rare. So if your employer wants you to reimburse them or penalize you because you did something, yeah, that's not legal at all.
Beside the fine, which we know they can't do, what else can an employer do? You know, if you put your employer hat on, like a performance improvement plan, what else can they do to handle that situation?
Well, certainly, if an employee is not doing a good job, if they're not meeting your policies, they're not doing what they're asked to do, well, then, yes, you can performance manage them. You can put them on a performance improvement plan. You can provide them a warning. You can tell them what will happen if they continue, maybe even give better training so that they understand what's expected of them and how to do it. So that's all under the rubric of performance management. And ultimately, if you've done all those things and you've tried and the employee doesn't care or is not able to do what's required, maybe then you can consider a termination for cause. But what you can't do is just terminate for cause immediately, and you certainly can't penalize someone by giving them fines or penalties. That's not legal. It does not work that way.
It has to be a hand up, not just a punishment. You've got to help them out, right?
Yeah. If you're going to show that this employee simply can't do the job, you also have to show that you've done whatever you can to help them, to support them, not just to say, well, the employee didn't do it, therefore they're gone. It doesn't work that way.
Again, pocketemploymentlawyer.ca for many details. Now we like to wrap up the show each week with the employment rights rapid fire. That is going to happen right now. So strap in. Here we go. All right, this is where we make Lior sweat for a little bit for a couple minutes, and we like to wrap up every week. Not that he's too tired, but that's okay. We're going to do it anyway. Number one, pal, here we go. Rapid fire. Is your employer permitted to ask about a medical diagnosis?
Easy one. You started off with, John. No. Your employer is not allowed to demand to know what your diagnosis is. Your employer is not allowed to know what your medical condition is. They're allowed to know if there is a condition and if it's going to impact your work and whether you need to be off or you need to be accommodated. But the nature of the condition is private. They don't get to ask. They don't get to demand. They don't get to ask for your doctor's files. That's private and personal. And yes, you have privacy rights.
Good stuff. Rapid fire number two. Can remote employees be reprimanded for power or internet issues? I have never heard that question before.
Yeah, and you know, a few years ago, we wouldn't have thought about those things because there wasn't remote work that much. But the answer generally is potentially yes. If you're working remotely, there's an expectation that you're going to do what you need to do on your end to facilitate that work. Just like if you're coming into work, you need to have a car, you need to arrange for transportation to get to work. And if you don't get to work, you can't blame someone else. The same thing with internet access. If you're working remotely, it's expected that you arrange to have proper internet or other tools to do your job. And if regularly those tools are not available, there's disruptions, you can't do your job, yes, you could be penalized for that. So keep that in mind.
So this is the updated version of the dog ate my homework.
Yeah, that's the 21st century version of that, absolutely.
Right. Rapid fire number three. Can an employee be let go for refusing unsafe work?
Absolutely not. Again, another easy one. You can, you should, and you must, in fact, refuse unsafe work. You should not work if your workplace is unsafe. You cannot be punished. Your employer has to take that seriously, even if it means bring an outside inspector from the Ministry of Labor to investigate. You're allowed to do that. You should do that. Nothing can happen to you.
Rapid fire question number four. Does an employer have to honor a verbal promise, such as a raise or promotion?
Well, the short answer is yes. Your employer has to honor that promise as long as you can prove that it was made. The problem with a verbal promise is there's no proof. And if your employer denies making that promise, you can't enforce it. Now, if you've recorded that verbal promise and you can show that it happened, absolutely. I'm not a fan of verbal promises. If your employer wants you to do something and they promise you something in return, get that in writing, even send them an email confirming that it was said. That's how you enforce it.
We started off with an easy one. We'll finish with an easy one as well. Lior, can a probation period be extended for longer than 3 months?
Again, another easy one, as you said. The short answer is no. For legal purposes, a probation period can only really last the first 3 months of employment, and only if the employment agreement says so. Beyond that, no, it can't be extended. It's meaningless, so don't stress out over it.
And that is Rapid Fire and the show this week. Thank you so much for tuning in and contributing, either through email or the phone calls. Thanks for watching as well. Reach out now anytime, 1-855-821-5900, help@employmentlawyer.ca. And the only website, you know it by now, pocketemploymentlawyer.ca. And we'll catch you next time right here on the Employment Live Show.